Our speaker for today is Patrick Elliott. Patrick is the Freedom from Religion Foundation Senior Litigation Counsel. Originally from St. Paul, Minnesota, Patrick received a degree in legal studies and political science from the University of Wisconsin-Madison in 2005. He attended the University of Wisconsin Law School and received his Juris Doctor in 2009. While in school, Patrick took an interest in the First Amendment and constitutional law. He joined FFRF as a staff attorney in July 2010 after working part-time for the foundation since February. Patrick is a member of the State Bar of Wisconsin and is admitted to practice in the United States District Court for the Western and Eastern Districts of Wisconsin. The topic of today's speech is the Theocrats Playbook. Patrick has come a long way to be here with us, so let's show him how much we appreciate it with a warm applause.
I'm happy to be here, in part because it was 7 degrees in Wisconsin this morning, so it's so much nicer. And you probably don't appreciate your weather, but this is really good weather compared to what we're dealing with. As was mentioned, I'm from the Freedom from Religion Foundation. I just wanted to see how many people are members of FFRF who are here, so a good number. If you don't know what we do, we work to keep state and church separate and to educate about non-theism. And when I joined FFRF in 2010, which has almost been 10 years, we've increased our efforts quite a bit. We now have 10 attorneys on staff, and I'm primarily focused now on a lot of our litigation efforts, a lot of our lawsuits. And besides our litigation efforts, though, a lot of the issues that we're working on relate to public schools. I would say more than half of the issues that we get in terms of complaints from around the country deal with people pushing religion into public schools. And so that's a big product of what we're working on. That's not the only thing I'm going to be talking about today, but that is a major issue that continues into 2020, even though we've had court decisions for a long time saying that that was not something that was permitted. Typically, we have around 10 to 15 lawsuits at any given time that are pending. I know we have some lawsuits, interesting lawsuits coming up that have yet to be filed. But that's just to kind of give you a general overview of where I'm coming from. And today my talk is the Theocrats Playbook, which is really to talk about what is the other side doing, and not necessarily just what they're doing on the ground in terms of putting up Ten Commandments monuments or putting in God We Trust in schools, but more so what are some of their tactics and what is their thought process like. I think exposing that helps think about how do we what can we do in response, how can we prevent these types of things. And so mostly I'm going to be talking about what they're doing and have what I call not commandments but suggestions, and in terms of how we can respond to some of those things. But first, I think I have a clicker here. Let's see if this will work. Because Martin Luther King Day is tomorrow, I thought this is a really fitting quote. Shortly after the Supreme Court ruled on a few school prayer cases, Martin Luther King was asked about what he thought about the decision. And so as you can see there, he says, "I endorse it. I think it was correct. Contrary to what many have said, it sought to outlaw neither prayer nor belief in God. In a pluralistic society such as ours, who is to determine what prayer shall be spoken and by whom? Legally, constitutionally, or otherwise, the state certainly has no such right. I am strongly opposed to the efforts that have been made to nullify the decision." So it's fitting just because of the time of year, but also that last part about the efforts to nullify the decision, because this is what we face is even when we have correct court decisions or the law on our side, there's always an underlying effort to undermine that. And so I think some of the issues that I'll be talking about from the playbook will address some of that. So we'll start off with the first, which I'm just calling marking territory. You can see here a Ten Commandments plaque that's pictured. And I think one of the things that people get wrong that are in our camp, in terms of state-church separation camp, not necessarily non-religious people, but is thinking that people want to put up Ten Commandments displays or to do something because they actually want to indoctrinate in what that actually says. Because I think you might think that is that, we need to teach the Ten Commandments, that's why they want to put these up. But I have some reasons, and I'll explain them, that a lot of times it's about marking a place as being a Christian place or the government as being a Christian government. And so this plaque, does anybody notice anything wrong with it, first of all? So there's 9, and then, I don't know if you noticed the Roman numerals, is 11. For the 9th commandment there is listed as 11. So you all looked at this really quickly, and we figured this out. Where this plaque actually comes from was a juvenile court judge in Hawkins County, Tennessee. This was in 2010, was petitioning to put this up in the Justice Center. And we received a local complaint about it, and we were working to say, no, we shouldn't put this up. But it was a little bit telling that a bunch of atheists figured out, hey, you guys are missing one of your commandments. And by the way, you have some numbering problems here. And why is that? That's because they aren't necessarily, you'd think this went before the county commissioners, this went before the community. The judge himself, who was portraying himself as to be a pious man, didn't realize that he was missing one of the most important commandments. He's missing adultery. But the reason why is because, they wanted to put up the plaque. They didn't necessarily care what the content was. And so I think this is something that we should keep in mind when why is something being done. Interesting follow-up to this, and actually my colleague Andrew Seidel has a book called The Founding Myth. If you're interested, you can click through and buy it on Amazon and give some money to the organization here. But he talks about this case, and one of the follow-ups to this judge is actually he was not following many of these commandments. And I don't know if he's still in prison, but he did go to prison for, let me see if I have what it exactly was. He went to prison in 2012 for theft of state funds, and then he faced additional charges for theft from clients and money laundering, and he also faced accusations of sexual harassment, so maybe it was intentional that adultery was not on there. But the reason I bring this up is for us to understand, in terms of what the other side is doing, is understanding their motivations is also important. So it's not about necessarily debating the merits of the Ten Commandments, it's about marking a place as being a Christian place. And one of the things we can do, and I think the group here has done a pretty good job about that, is let people know that you're here. We've been successful oftentimes when, not necessarily at the state legislation, but at the local level, when there's proposals to put something like this up. If there's even a minimum number of non-believers or Jewish people, Muslims, or other people who say, hey, we don't want our community to be identified as a Christian community, we've had some success in stopping those types of violations. So that's the first play in the playbook, is marking territory. Keeping with the Ten Commandments theme, lie a lot is the second play. And this is a photo from, you can see the school name a little bit, but Valley High School is in New Kensington, Pennsylvania. This was taken around 2012, and which was around the time that we had a lawsuit over this to try to get this removed. And we had a parent, Marie Schaub is her name, and her daughter challenging this, and they faced a lot of pushback in their community, and a lot of problems in trying to get this resolved. This shouldn't be that hard of a case to pursue in front of a public school because we have a Supreme Court case from 1980, Stone versus Graham, saying you can't put up the Ten Commandments in public schools. But we had this school system that was refusing to do it, and we had to pursue a case. But one of the interesting things about the case was that they, the lawyers had to argue in both their brief to dismiss and ultimately on summary judgment to say, well, yeah, we have this monument here, but it's not like this other case, Stone versus Graham, where people might look at the Ten Commandments and meditate on them and engage in some religious practice. So basically they were arguing that, yeah, we have this up, but nobody's really doing anything religious surrounding this monument. And why I have this connected to this theme, and the lawyers in the room, and I know there's a few of you probably know about the discovery process. You can request documents and take depositions of the other side. And when we got documents from the school district, we found something interesting from the former superintendent who wrote to a former student. I like the way you said that you always said a little prayer. I can barely read this, but when you pass the Ten Commandments, I do exactly the same thing every time I walk by. He spelled by wrong, but anyway, it's interesting that, particularly when we're in these cases, everybody knows what we're talking about. We all know, both sides know that we're dealing with this religious thing, but in order to justify what they're doing, they often will try to secularize or claim, oh, no, this isn't a religious monument, even though the superintendent of the school system is telling a former student that he thinks it's religious and he prays every time he walks by it. This does have a happy ending because although justice is slow, as some of you may know from your own case, in 2017, I have an updated photo, so it's been removed. We, after court rulings in our favor and the school system having to pay not only its own attorney's costs, it had to pay our attorney that we were working with as well as some to FFRF, I think it was about $163,000 after 5 years of fighting this, to finally remove the monument, which they could have done a long time ago, recognizing it was being used for religious purposes. So the suggestion that I have here, and this is actually one of the more difficult things to address when the other side's just not telling the truth on things, is really to confront the lies, and you can. And the ways often that are done that is by gathering evidence. And so in our case, in a lawsuit, you can request those documents. But you also have public records laws that will allow you to check in on things as to whether, either in the school system or the government otherwise, to check what they're saying, to see whether it's actually true, and to ask questions. In a lawsuit, we can obviously ask questions directly to the witnesses, but you can ask questions to your officials and elected leaders about what they're doing and why they're doing it. Do I have? Oh, I do have this. Does anybody recognize this? What is it? Yes. Okay. So this is a 40-foot cross in Maryland. This is was the subject of a Supreme Court case, and it was recently decided, unfortunately, allowing this to stay. This passed in 2019. The Supreme Court allowed it. But why I've put this under the lie a lot category is because if you had read some of the briefs by the groups defending this, this is not a cross. This is a cross-shaped memorial, and so. One of the problems we've had in some of our cases, and this wasn't our case, but is dealing with things like that, where everybody can see this and knows that this is a cross, and that's what it is. But the ability to mask the truth is something that that can be confronted. And so not just us, but the American Humanist Association, in responding to some of that, had to point out the obvious, that this is a cross. Why do they have to be telling you this? Obviously, the religious people think this is a cross. That's why a religious group is defending it. So anyway, I point that out because it's something that, in terms of the suggestion, in terms of how to confront it, is just pointing it out when we see it. And so we have to, unfortunately, point out something as obvious as this being a cross, and it's not just a cross-shaped object or cross-shaped memorial. The third tactic that I wanted to bring up relates to, I'm just calling it style over substance. And I have just a graphic here from one of our cases out of West Virginia. And if you've ever been to a government meeting or city council meeting, you may well have seen this. Oftentimes there's an invocation or prayer to start the meetings. In Parkersburg, West Virginia, they have, for at least over a decade, say the same exact prayer, the Lord's Prayer, at every single meeting. So it'd be hard to go attend one of these and not come away with the idea that this is the official prayer of the city of Parkersburg, and that it's a Christian prayer. Obviously, it comes from the Gospel of Matthew. Part of it comes from the Gospel of Matthew, and part of it is a doxology, basically part of a religious service. But anyway, the city of Parkersburg was doing this, and we wrote to them about the prayer, because the obvious problem is they shouldn't be opening their council meetings with an exclusionary prayer. Particularly in the federal jurisdiction that they're in, there's very strong case law on this. Unfortunately, where you are, you don't have the same case law to tap into. So we wrote to the city, and one of the things they did in response wasn't to stop saying the Lord's Prayer. They stopped putting it in their agenda and stopped putting it in their meeting minutes, and they would say the Lord's Prayer, say the Pledge of Allegiance, and then they would gavel the meeting to order. And so they obviously thought, what I'm just calling technicalities, that somehow that they could get around the Constitution by making a minor change. And it's a pretty common tactic that we see. I think the idea is not how could I continue doing exactly what I'm doing with minimal change instead of how can I comply with the Constitution? That's a thing that we see, and I think that groups that work on these issues see all the time, is that they want to just change something and think, oh, that's going to fix it. Obviously, it didn't fix it because after we explained why that wouldn't count, we filed a lawsuit. That lawsuit's still pending, actually, and we're still working on it. But the idea that a technicality can somehow fix this. The other example that I have of this, and actually some of you may be familiar with this because of your Ten Commandments monument, is there's this idea that as long as we don't spend any government money, that's okay. So the fact that the monument at the Arkansas State Capitol was privately funded makes it somehow okay. So there's already this idea there that it would be inappropriate to fund it publicly, which should signal to you that you can't put it up, on public property. And that's not just in the realm of displays. There's also, and actually this is a case that we're watching closely that I think is probably the most important U.S. Supreme Court case this term. There's a case called Espinoza versus Montana Department of Revenue that the Supreme Court has decided to take and has had briefing on. And one of the issues there is, and maybe you've seen this in some other places, there's basically a voucher scheme to provide money to private religious schools. And so in Montana, so the state, under the state constitution, couldn't just fund private religious schools. They're prohibited. So they come up with a workaround. And the workaround was you, on your taxes, instead of paying what tax liability you owed, if you owed the state $150, you could donate $150 to a scholarship organization, and then you'd get a dollar-for-dollar credit on your taxes. So basically, it's just like a tax credit, complete tax credit. And then that organization funds the private religious schools. Unfortunately, this has worked in some states. Some of the state courts and their state decisions have allowed this. Montana, this case went to the Montana Supreme Court, and they said, no, our state constitution does not allow us to do this, to do this scheme. It's really a technicality. The spirit of the Constitution is we can't fund private education, including private religious education. So they scrapped the whole program. That case was appealed to the U.S. Supreme Court, which took it, which is deciding whether basically that violates the free exercise rights of the parents who wanted to send their children to school. So giving examples of this, what I'm calling technicalities, I think everybody, including not a liberal Montana Supreme Court, decided that this was, technicalities weren't going to get them out of it. It is something that that the Theocrats think, that they think that there's some easy fixes that are going to allow them to do the bad stuff. And thankfully, in some instances, there's courts or people willing to put their foot down and say no. This is I made up all these titles, but heads I win, tails you lose is what I'm calling more so what I think we deal with in some of the cases that we deal with, where being a litigant on, expressing civil rights on the side of preventing the Establishment Clause from being violated, we have a lot of uphill battles that are being fought in court, and even just having our cases heard. Some of you maybe have heard the phrase, standing. Does somebody have standing in court to challenge something, which generally means, is this the right type of plaintiff? Has this plaintiff been injured? And is there something the court can do to address the injury of this plaintiff? And it's applied really rigorously to cases. FFRF had a case that we lost in 2005, way before my time there, but in 2005 before the U.S. Supreme Court on challenging government funding for faith-based programs. And they said, well, you don't have standing, and made it much harder to challenge. And other organizations have had this problem too. And why I'm putting this in the heads I win, tails you lose is because you'd think that the same rules that would apply to us on our cases should apply to their cases too. That's not really what's happened, both from the religious groups that have been bringing those cases, but then also from some of the courts and how the courts have treated them. So in that Espinoza case that I mentioned, when the Montana Supreme Court issued its decision, it basically scrapped the entire program. So the legislature approved this program, they never had any funding like this for a long, until very recently. And the Supreme Court said, okay, no funding to private schools because our Constitution requires us to fund public schools and not private schools. So it wasn't just that the schools were religious, it was, which all of them, or nearly all of them were, it was nobody could get it. And so that's a big deal because that's basically putting the state back to where it was before it had a system that funded private religious education. So what's troubling about this is that the Supreme Court wanted to take this case because it's a little baffling that a program that says, okay, no funding of private schools, somehow would violate either the free exercise rights of somebody because they're not being treated any differently than anybody else, or they also are deciding whether it violates equal protection. So whether this group of plaintiffs, this group of parents is being treated than any other group of parents, which on its face doesn't make any sense. If this was a case that we were bringing, we would never be at the Supreme Court. They wouldn't take it. But I think the rules become, this heads they win, tails you lose, the rules become a lot more lax when it's an issue that they want to rule favorably for a group that they agree with in terms of the substance. But there's real problems with this case. So we'll see if the Supreme Court is going to, a good resolution would be the court to say we shouldn't have granted review of this and the case would be over. But if they get into the actual issues, it would be a problem because any number of other states, which pretty much all states have some state protection in your state constitution, could basically be partially invalidated by the federal constitution. So even though the federal constitution might allow a voucher scheme to take place, there are states like Montana or Florida that say, okay, we're not allowing that. Here we're going to have a Supreme Court that's going to say, oh, you must. No, that would violate free exercise if your state constitution, didn't provide for this. So it's certainly a problem in current cases, and in some of the past cases that I've been, that we've watched that aren't necessarily all Establishment Clause cases. But I don't know if, probably many of you are familiar with the Masterpiece Cake Shop case. Out of Colorado, there was a baker who refused to bake a cake for a gay couple who wanted to use the cake for a wedding. And one of the problems with that decision, it's not a very good decision because it doesn't really resolve future disputes, but one of the problems that Justice Kennedy wrote about in that opinion was about hostility, apparent hostility to the religion of the baker. And cited a few rogue comments that were made throughout the adjudication of the underlying discrimination complaint. And why that's a problem is, well, one, I don't think substantively the comments were actually anti-religious or were by a decision maker that had authority to actually, that was their actual rationale for why the cake baker's decision was discriminatory. But in our cases, if we try to show hostility, we have hostility in spades. They're always saying bad things about the atheists, the Satanists. If we cited to something like that and say, case over, this person said this horrible comment, that would never work. It's never worked. So it's just the hypocrisy, I think, of when there's a rogue comment here, the court obviously thought it was a really big deal. It wasn't really a big deal in the underlying case. Certainly, so it was kind of surprising that the Supreme Court thought it was a big deal. And you can contrast that with how the Muslim travel ban case was treated. There you had President Trump saying very overt things about he didn't want Muslims to enter the country. And then there were varying executive orders that followed. The court basically gave a pass to that hostility, which was overt hostility, and he was the actual decision maker, compared to a case like Trinity Lutheran, where it was just a rogue comment, and the court was so bothered by it that it included a discussion in its opinion. So just some of the challenges we face on the state-church separation side are, I don't think we're always getting fair treatment by the courts because they're giving a pass to the other side. And so the suggestion I can have in terms of what our cases are, but also just for people, is really asking for equal treatment. So one thing that we're doing and other groups are doing is filing friend of the court briefs or amicus briefs in other cases. So we filed a brief in that Espinoza case, and we'll be filing other briefs with the court, but at least pointing this problem out, because it would be really disappointing if we're going to have these kind of two standards applied, depending on if you're a religious plaintiff or you're an atheist plaintiff, you should have the same rules should apply to you. And I'll show this and you can enjoy it for a minute while I grab a drink of water. So this is an actual visual aid used in public school classes in Mercer County, West Virginia. They've had, for almost 80 years, they had Bible classes for their first through 8th grade, which it's thousands of students per year. And so this is one that we ended up, I guess I got a copy of it when we first did, we did a public records request to kind of see what the curriculum was. And so part of what we found then is that some of the curriculum was promoting creationism. And there were some lines that were in the teacher's script that go along with this that I'll read. So students were asked to, quote, picture Adam being able to crawl up on the back of a dinosaur. He and Eve could have their own personal water slide. Wouldn't that be so wild? And so, you had this public school curriculum that was, promoting, besides just the religious angle, really an anti-science teaching in school. And they had been doing this for a really long time. And I think, why this is, there's a number of reasons why this is a problem. One, because it's, factually not true. But also that it's kind of surprising that a lot of the people who don't want the government involved in a lot of aspects of their lives really want the government to teach other people's children or their children, one of the most personal and important things to them, their religion. And so just from this is kind of a legal term, but I'm using it more broadly, in terms of entanglement, in terms of having the government involved in some aspect of religion, because you'll see oftentimes religious organizations like schools that employ teachers fight against, having to comply with things like discrimination laws or the Americans with Disabilities Act, because they say, wait a minute, our teachers are actually ministers. This is another case going before the Supreme Court on that issue. But oftentimes, when they don't want any government involvement in terms of, is it contraceptive mandate, is it complying with these other discrimination laws? They don't want government involvement, but they really want government involvement in one of the most personal things, which is, teaching your child about religion and what to believe. They want it. So that's just I guess it's not surprising in terms of that there's hypocrisy in this world, but you'd think that we could agree on the entanglement idea. And I think that goes back to the Martin Luther King quote, because he obviously was explaining that thing. We don't want the government picking certain prayers. We don't want the government doing these types of things. But here, they've made decisions that they're going to teach a religious curriculum. They think it's permissible, by the way. They think that this curriculum was permissible. So we challenged this. We sued with some families, and one of the problems with one of the families that we sued with was that because they were so mistreated in the school system, because when they opted out of sending their daughter to this, the daughter then would just sit by herself. So they sent her to the library to read by herself, and this is from, first grade for the next few years. And so it's really ostracizing to a student to have to endure leaving your class, making a big deal, and then ultimately being bullied and being told you're going to hell, which is, of course, what follows when this is kind of thrown into the public school context. So the mother, Elizabeth is her name, and made the difficult decision to remove her daughter from the school system, continuing to live within Mercer County, but sending her to a different school system. Well, once she did that, in our case, the school system argued to the court that she doesn't have standing anymore because she doesn't attend the school. So that's a fight that we were fighting in the district court, which the district court agreed and said, okay, she doesn't have standing, she's left the school system. We appealed, and last December, so December of 2018, the Court of Appeals ruled in our favor and said, no, she can pursue this claim because she's avoiding the unconstitutional conduct that you're doing. You're teaching this. She is avoiding it. So that was a favorable decision, and thankfully this fall the Supreme Court declined to hear that case. But the case is still pending because that was all a fight about just whether she was able to even get through the door, to get through the courthouse door to be able to, to be able to fight it. So it's really sorry, where's my notes? It's really a problem, it should be easy to explain. We don't want government involvement with religion, and a lot of people will say that they agree with that. But it goes out the window when it's their religion that's being taught. And I know that a lot of people agree with that, but it's something here that we shouldn't have had to take a lawsuit over. Thankfully, the good news is they have since stopped the classes. The case is still going on because they could potentially resume if the case were to go away. But for the first time in about over 80 years, their kids are now not having Bible instruction in Mercer County schools, which was about 4,000 students per year that were getting this. So I'm pleased with that. They've decided to stop the classes. We'd hope that there would have been compliance beginning in 1948 when the Supreme Court said you couldn't do this in the first place. But so my suggestion, and this is the last of my 5 tactics, is really when we talk about state-church separation, it's not just about whether creationism is true or not true, but we're talking about government power and abuse of government power. And so I think sometimes people are often treating, including atheists or non-believers, talking about how absurd this is, which it totally is. But the problem is really the use of the government to disseminate this to impressionable and young students. So to harken back to I think what the Martin Luther King quote was saying, which is, the government doesn't have a place in deciding, what religions are true, what specific prayers to say, and certainly not, what religion to teach children. So those are my, the 5 tactics that I've observed. Again, I kind of go through a few different violations that are used by, both our justice system, but also, people in office, and I'm calling them theocrats because they want religion in government. And I'm happy to take any questions anybody has. Yes, over here.
2 things. I thought you might give us an update on our Second Amendment case. And then second, my understanding, and I stand to be corrected, that Arkansas has a state law that requires public schools to post in God we trust. And where is that in the pipeline?
Yeah, well, Jerry Schulze is our main litigation attorney. He's here today on the Arkansas case. I was trying to avoid that a little bit because the case isn't over. Within the next several months, we'll be able to file our side on behalf of Ann and the other plaintiffs. We've also retained an expert in this case because one of the justifications for the monument has been that it's somehow tied to American foundations of government, and our expert is basically pointing out how that's not true. So we can expect, all sides to really file to have a court decision on this. We can't control when the court ultimately decides it. On the second issue of In God We Trust in schools, I agree with you. I'm not familiar with the Arkansas specific law, but this has been a big push by this organization calling itself Project Blitz, was trying to put these things in a number of states as a coordinated effort. And one of the difficulties with challenging, the In God We Trust display is there's a number of cases that have, haven't really probably ruled correctly, but are difficult to contend with in terms of, they've justified it as being, sometimes courts use the phrase ceremonial deism. It's like, just because through a long period of time and use, it's really lost a lot of its religious significance. And in this case, they're going to point to it being, the national motto. So it's difficult to pursue. I expect that it might be challenged somewhere. Unfortunately for you all, I don't know that Arkansas is the place to be for that, because you have to win. You have to go through the court system, and your Court of Appeals is also not very favorable to state-church separation. So that's a potential problem, and it doesn't resolve the concerns currently, but it's an explanation for why I think that's going to probably continue for some time.
Yeah. As an Arkansas teacher, we can't be required to put them in the school camp by them. but another person or another can do that violence, and they can be dangerous. And it says that administrator may place them on a lot of salaries, and we all were supposed to go ground buster. I mean, that's never set it up. But some of my friends actually.
We actually have an alternative poster that has other mottos. And the one that we received at our district, the church function has, God, behind God is fireworks and all that stuff. And it was actually technically in violation of the official rule that said how the poster has to be constructed. So then we got another one. I think we were three funds or who provided that. And so, in the cases where schools do receive these posters, teachers do have another option. Unfortunately, though, as the law is currently written, if someone privately burns the posters, then you may have to put something that you in the room or in the building.
Yeah, I mean, it has a an enforcement problem too, which is how many classrooms across the state are there? I mean, there's a ton of classrooms. Some other states have dealt with this in interesting ways, and I believe it was in Kentucky. Their law maybe wasn't crafted as carefully because they had people were coming up with interesting ways to display it. So there was a school that had basically an old dollar, an image of an old dollar, and the pre-1952 dollar, and explaining why. Basically, it wasn't a favorable poster about explaining. We have to put "In God We Trust" up, but there wasn't any requirement of what the particular poster had to look like or what the size or any of that would be. So some schools in Kentucky have come up with interesting ways of using it as a teaching opportunity to talk about this, but I think that was definitely not what the legislators intended. They wanted to have God in every classroom. Yeah, Ann.
I will say something about those posters. American Atheist is looking for a plaintiff in Arkansas, and we're kind of the clearinghouse for that. So if you want to contact me, if you're willing to be a plaintiff, this is the problem, is that someone who's willing to be a plaintiff who has a kid in the school system who is going to subject their kid to bullying, essentially. But American Atheist also has alternate posters, and it may be the ones that you're describing because it has E Pluribus Unum, bigger than "In God We Trust," and explains the difference and the change of the national motto.
Yeah, Chris.
Just kind of strategically thinking, if I'm a theocrat on a school board and I'm going to violate, numerous judicial precedents yet again, I don't really have any skin in the game, because if I'm a member of the religious right, I might not be a big fan of public schools to begin with. And so if I, decimate the bank account of my school district by digging my heels in on this issue and fighting something through the courts, then, maybe they don't care if the resources get used up that way. And so maybe it kind of makes me think that we all need to think really hard about school district elections and maybe call these people up and ask them what they think about stuff before, because once they get entrenched in those positions, they basically can waste tons of money doing political litigation.
Yeah, I think, I'm agreeing with what you're saying for the most part. One of the issues with these people value their personal religious beliefs higher than the education of children that they're supposed to be overseeing. So that's why sometimes, like the New Kensington lawsuit could have been resolved before we even had to do anything. It would have cost the district $0 had they just said, okay, we're going to move it to the church down the road or wherever they were going to put it and put children's education first. But instead we had, a 5-year battle where they had to pay their fees. And I think insurance money ultimately had to pay our fees on the end. But it's I think if you give that opportunity to somebody on a school board, they might make the wrong choice. Instead of valuing children's education and the resources of the community, they'll say, oh, I got to defend my religion.
I'm Doris Hutchins, and I'm from Conway with an atheist group there. And I was wondering, how many Freedom from Religion members do you have now, and then how many are in Arkansas?
I should have done my. We have 30,000 members across the country. Okay. I don't know our Arkansas numbers offhand. I can give you a pretty good estimate, which is it's around probably a few hundred.
Okay. And I was just curious, when I was growing up, I grew up at Valonia, which is northeast of here, east of Conway. It was probably in the early 60s, and they had a Pentecostal lady come, or Assembly of God, some church, come in, and every Wednesday at noon during the free time, we had an opportunity to attend a Bible class in the auditorium. She would use her flannel board and, put those kind of pictures on it as she taught a different Bible story. And I wondered, could I see a show of hands of anybody else in here who ever had to attend that in any state or school? Okay. Where were you? In Utah. Okay. Wow. Okay. And then the other, I had three-pronged questions. I don't think you've given us an update on our Ten Commandments statue or monument in Little Rock. Were you planning to do that?
Oh, it was asked, but it'll be briefed within the next few months, and we can't control when the court will issue a decision on that. As you may know, there's other parties involved in that case, including the Satanic Temple, and so that's complicated or delayed things to some extent. Jerry can attest to that. Any other questions? Yes.
You just brought up an issue that I do have a question about, with the Satanic Temple working towards some of the same things that I hear you working towards, and then your organization. I wanted my dollars and my support to go to the most efficacious use of my money and my support. How do the other organizations like the Satanic Temple, which I have supported, how does that complicate your job? Or is it making things worse or better? Are we dividing and being conquered? Are we dividing ourselves and being conquered?
I think there's different approaches. I think if you look at what their mission and goals are, it's going to align with, the Arkansas Society of Freethinkers and FFRF and other groups. There's different ways of approaching it. So oftentimes they're helpful / useful because, for instance, they came up with the Satanic Coloring Book. I don't know if you've seen this. It's a cartoon, which is kind of humorous, but it actually teaches really good lessons. And one of the ways that was useful to us was when schools were doing Bible distributions, and we had to say, okay, don't do Bible distributions. And then they'd come back and they'd say, well, wait, we have this neutral policy that allows for Bible distributions 1 day per year by putting things on the table. And then we said, some of our members were like, okay, fine, I want to do the Satanic Temple Coloring Book. And then the schools came back and said, okay, no more Bible distributions. So it is useful in that sense because we've had weird instances where they'll allow like free thought literature, but anything satanic is viewed as worse. I will say, in terms of putting up monuments and things, we may have a disagreement about whether that's the proper approach, but I think they've been dealing with the hand that they were dealt with, which was the state was claiming that there was the system to put up monuments, and they were pursuing that. As a matter of law, in 2009, the Supreme Court ruled on a case where, actually out of Utah, I think it's the Sumum versus City of Pleasant Grove, where basically there's a Ten Commandments monument that had been up for a long time, and the Sumum wanted to put up their aphorisms and sued over it, and they were pursuing a free speech claim. Went to the Supreme Court, and the Supreme Court basically said, hey, monuments on public property are speech by the government, which I think is correct. I think we all know that when you go to the Capitol, you think that's the speech of the government, not by the organization that donated the monument. So there may be some legal differences in any particular case, but overall I think we're all working towards similar goals, and there's just different approaches. And sometimes their approach is really useful, like the equal treatment idea that a school's not going to want to do that. And sometimes it may just slow down your case, but I don't think it'll necessarily change the outcome. Yeah, so.
I just wanted to make a comment. When you go back up to Wisconsin, tell Andy Seidel that was a wonderful book.
Oh, great.
That really was worthwhile reading.
Oh, thank you. Yeah,
I bought 2 copies for other people.
I mentioned it before. So Andrew is another one of our attorneys, although he's kind of shifted his focus to a lot more of the legislative efforts and things that we're working on. But he wrote a book called The Founding Myth, and he talks about the Ten Commandments in there and the story of the judge in Hawkins County, Tennessee that I was talking about with the plaque. He talks about that as well in his book. All right, well, thank you, everyone.